I don't know. Ask Gwen. Gwen, Ms. Weber, you'll be out there and come in?
What, is it 4 you're on?
No, quarter up.
Okay, I think that they are going to approach.
Do pretrial?
Sorry.
I told us that before doing our opening statement.
No, you're going to have to be loud.
Okay, because he said that the stream nobody can hear us. Oh, he said if you want,
If you can
Test,
travel-
test.
Yes, if you can travel with it, go ahead.
no, for my opening.
Let me tell you. Sorry. Closing will be the same way. You guys will come up when you close. Mr. Goucher said that he's having a hard time picking up, alright, the sound. So if you can take your microphone with you, please do so. Sorry about that, yes. Okay, yes, sir. Okay, great. Yes, okay. Don't take it up to the bench. Okay.
Okay.
Let me grab the chairs. Not yet, it's gonna, and it's gonna go to Mr. Goucher or to me, so then you know, or either there.
He's outside.
$5 donation to Dr. Weber's favorite charity to go.
Legal studies program.
Your Honor, may we approach?
Yes, you may. Are there any pretrial matters before we call the jury in and get started?
Okay, so we have a few motions.
Let's get
sir.
counsel up here, please. All right, what do we have from the defense? Have you shown this to the state?
Yes, we have.
Okay,
Yes.
any objections on the behalf of the state?
Any objections, sir?
All right, then defendant's motion in limine will be granted. Anything further from the defense?
As far as the states, we do, pretty much, the low cause number, wrong jurisdiction, Pretty much all garbage. 13 objections.
Okay. A timely objection, all right. Other than that, do you have any objections to the terms?
No, we do not.
Okay, then those are generally thought of as typos in ministerial matters, so we'll overrule those. And if you have no objections, then the state's motion will also be granted. Anything further?
We also like to invoke the rule. So.
All right, we will do that. There are any witnesses in the room who will be testifying who are not parties to the case. If you would stand at this time and be sworn, you may take your seats. Please raise your right hand. Do you swear or affirm the testimony you are about to offer in this matter will be the truth, the whole truth, and nothing but the truth, so help you God? All right, the rule has been invoked. That means that you are not allowed to be in the courtroom except when you are testifying. You are not to discuss your testimony or the case with anyone other than the attorneys involved in this case. So we will ask that you be
Your
excused
Honor?
at this time. Yes, ma'am.
There are witnesses in here at this time.
More than those two? Oh, well, as I said, any witnesses, please stand. You two have already been sworn. Please raise your right hand. Anyone else? Right hand. There you go. Do each of you swear or affirm the testimony you are about to offer in this matter will be the truth, the whole truth, and nothing but the truth? So help you God. All right. Again, the rule has been invoked. That means that you will not be able to be in the room except when you are testifying. Ms. Weber, are we excusing? Do we have a room?
I'm looking for one, Your Honor, yes, they can be excused from the courtroom.
All right. Please step out. We'll call you in when we need you. Other than the defendant.
I'll let you call it that. It's not until, I don't know why we can't start it if everybody's ready.
Your call. Okay.
You might want to step out.
Okay. We will begin trial in just a few moments.
Oh, thank you.
Are you all ready to go? Everybody ready to go early?
Yes.
Okay. Just because it's not London, but there's no
Anytime the jury is standing or the judge is standing, please rise. All rise. The mock court is now in session. The Honorable Judge be presiding.
Good afternoon. Please be seated. All right, we will call 17CR 9711, State of Texas versus Jordan Young for trial. Is the state ready to proceed?
Yes, Your Honor.
Is the defense ready?
Yes, Your Honor.
Yes, Your Honor.
All right, I'll call upon the state to read the indictment. The defendant, please stand to hear the indictment.
The grand jurors for the County of Hawk, State aforesaid, duly organized as such as the January term AD 2017, upon their oaths in said court, present that Jordan Young, on or about the 9th day of September 2017, and anterior to the presentment of this indictment in the County of Hawk and State of Texas, did then and there cause the death of Danny Walker by being aware of the risk of hitting another vehicle if he was not watching the road, and by disregarding that risk when he read and responded to text messages while driving, which is a gross deviation from what an ordinary person exercising ordinary care would do under the same circumstances.
All right, Mr. Young, you have heard the indictment. How do you plead to the charges? All right, your plea of not guilty is entered. You may be seated. Would the state like to make an opening statement at this time?
Yes, Your Honor, we may.
You may proceed.
Hello, ladies and gentlemen of the jury. I'd like to introduce myself. My name is Marissa Bones. I am one of the state prosecutors for Texas. At this time, I would like to ask you to please close your eyes for a brief moment. Imagine yourself, a 17-year-old self, driving down the road in a motorcycle. The wind is hitting your body. Someone veers into the wrong lane. You're being thrown 185 feet away from your motorcycle. You may open your eyes. It's not like jumping on a trampoline. It's not like when you're jumping on a trampoline and you're receiving that cool breeze. That's not what's happening here. You're a tiny rock. You're being violently flung with a massive amount of force. Now I want to ask you to think what your last thoughts would be at this very moment, or your loved one's last thoughts would be. You are forever losing the opportunity to taste, smell, or touch life on earth ever again. You're lying all alone for 12 minutes until you die of your injuries. This moment that you just experienced happened on September 9, 2017 to Danny Walker. I wish I could tell you where it was that Danny Walker was going or coming from. Unfortunately, we're not able to do so. Because of the defendant's selfish, reckless act, he took Danny's life away far too soon. The defendant, instead of keeping his eyes on the road, he chose to look at his phone and respond to several messages. Between 1:58 p.m. and 2 p.m., the defendant sent and received 19, 23, and 27 text messages, a total of 69 texts via voice. Instead of pulling off the road and responding, as a reasonable, prudent person would do, the defendant chose to behave in a manner that was irresponsible and reckless. As a result of his actions, Danny Walker's life was taken. Evidence will show that the defendant admitted to looking away from the road as he looked at his phone to see who texted so that he could read his messages. You will learn that Danny died due to the defendant's recklessness, disregard for his own safety and other people on the road. The defendant knew the risk of texting while driving. In order to obtain a driver's license in the state of Texas, you have to go through a course. And in that course, it stresses that texting and driving is very dangerous, and you're advised to pull off the road and answer or respond if it's urgent. You will learn that Danny did everything right in the expert's opinion. He did everything in the law's eyes of our state required for a person that wants to receive a motorcycle license. Danny attended motorcycle education course. He earned a learner's license by passing the motorcycle written knowledge exam and the motorcycle road skills exam. Danny properly trained, and he demonstrated these skills by the day of the accident. He took his training seriously. You will learn that Danny stopped 50 feet ahead to avoid the collision. However, the defendant still did not see Danny Walker. As Danny sat there and waited, he was struck at most likely 60 miles per hour. It wasn't until he felt the impact that he realized he had hit someone. He jumped down and he saw a bike, but he didn't see a person. So yes, Danny called 911 immediately. But even though it was an accident, just because it was an accident does not mean that he shouldn't be held responsible, because it was an accident that resulted from the defense recklessness, and taking a life is a crime in the state of Texas. Thank you.
All right, thank you. Would the defense like to make an opening at this time or reserve it for its case?
Yes, Your Honor, we'd like to make it right now.
All right, then go right ahead.
Ladies and gentlemen, I submit to you that I can sit here right now and not say a word. By the time the state's done putting on the evidence, you're going to have a lot of unanswered questions and doubts. Certainly I'm not going to do that. I'm going to highlight some of those facts for you today. And when the state's done, you're going to think, man, they fell way short. The evidence really did not prove beyond a reasonable doubt that texting was the sole cause of Danny Walker's death. Yes, Jordan moved on to oncoming lane. But the unanswered question is why? Now the state's going to show you records, phone records today. That does not show you when, during the course of a minute, those texts were sent. Was it the first 10 seconds? What about the last 50? And those are crucial. Those are important. And that's a critical flaw for them that they're not going to be able to point out. Another thing is they're not going to be able to demonstrate to you whether Jordan had a medical episode prior to the accident. And by the time they put on this whole case, like I said, you're going to have serious doubts and questions. And that is not enough to convict Jordan Young of manslaughter. Those doubts, they're going to stick with you. You're going to think, man, there is holes in the story. It's not in black and white. There are gray areas. So that's what we're going to do. We're going to point out those holes for you. Yes, this was a terrible accident. Yes, it was a tragedy. Jordan, this was a tragedy. Someone was killed. And your willingness to point the blame is what they want you to do. They want to play off your emotions. They want to pull on your heartstrings. Think about that as you're being presented all this evidence today. Don't look at it from a micro perspective. Look at it from a micro, not macro, micro perspective, all right? The state has to present evidence beyond any and all reasonable doubt that the theory behind which they are making the accusations, they're not foolproof, and I beg to differ. Now, don't let your willingness and your want to bring back closure to the deceased family, don't let that turn into evidence, because it is not. It is not. Now, don't use those emotions against my client, because that is injustice.
All right, thank you, Mr. Singh. Please call your first witness.
Your Honor, the state calls Detective Harper Miller to the stand.
Detective, please come up and take the witness stand. I will remind you that you have previously been sworn. All right, you may proceed.
Thank you, Your Honor. Can you please state your full and legal name?
Harper Miller.
What is your current occupation?
I'm an officer at Georgetown Police Department.
How long have you worked there for?
17 years.
What kind of experience do you have working in traffic collisions?
I've been on collision patrol for 6 years and part of the vehicular homicide unit for 11.
How are you connected to this case?
I was called out on September 7th, 2017 on Highway 29 to investigate the scene.
What date did you say again?
September 9th, 2017.
What county and state did this collision occur on?
Hawk County, Texas.
Objection, Your Honor. It's the wrong county. It's actually in Harris County.
No, Your Honor, that is incorrect. In the indictment, it says Hawk County in the state of Texas.
All right, it's an element of proof. If it's wrong and they don't prove it, you have a point. Overruled.
Thank
You may continue.
Your Honor, may I approach the witness?
You may.
What I am handing you is marked for identification as States Exhibit 1 and 2. Could you please tell me what they are without getting in detail?
Their photos. Their photos. Exhibit 1 is of Highway 29 and Exhibit 2 is of Danny's motorcycle.
Are both exhibits fair and accurate descriptions of Highway 29?
Yes.
Is there anything different?
No.
No? Okay. Is this the motorcycle that you saw on September 9th, 2017?
Yes.
And is this the same highway that you saw on September 9th, 2017?
Yes.
Okay. Your Honor, the state tenders Exhibit 1 and 2, marked for identification purposes only to the opposing counsel for any objections. Furthermore, the state would like to offer both exhibits into evidence.
No objections, Your Honor.
States Exhibits 1 and 2 will be admitted.
Your Honor, may I publish this to the jury?
Yes, you may. Straighten it up a little bit so they can see it without it.
Yes, sir. Mr. Miller, when did you arrive to the scene?
Before 2:15 p.m.
When you arrived, who did you see?
I saw EMS, several patrol officers, and Jordan Young.
Is Jordan Young here today?
Yes.
Could you please identify the defendant? Yes. Your Honor, may the record reflect that Detective Harper Miller identified the defendant as Jordan Young?
Objection, Your Honor. She actually hasn't. Normally there's a procedure where they do by clothing and all that, and which the witness has not proven.
Have her identified by position in the courtroom and type of clothing he is wearing, and so we have something for the record.
Yes, Your Honor. Detective Miller. What color shirt is the defendant wearing in this courtroom?
A light blue shirt.
Could you please point at the defendant in the blue shirt?
Yes. The one at the end.
Okay. Your Honor, can the record reflect that Detective Harper has identified Jordan Young as the defendant?
The record will so reflect.
Thank you. Detective, what did you find the day that you arrived at the scene?
When I arrived at the scene, I saw Jordan's truck. There was damage to the front driver's side and the side of the vehicle. There was also 2 sets of skid marks on the eastbound lane, and then Danny Walker's motorcycle was about 100 feet from the marks, and then his body was about 185 feet from the road.
Did you ask Jordan what he was doing when he hit Danny Walker?
Yes.
What did he say?
He said he doesn't recall.
Okay. How did you ultimately conclude that Jordan was not watching the road at the time of the collision?
I concluded that he wasn't watching the road because the skid marks showed that whenever he was driving, he swerved into Walker's lane and he didn't stop until he already hit Danny.
Based on your experience, would you say that texting and driving is dangerous?
Yes.
What is the speed limit on Highway 29?
60 miles an hour.
In your opinion, a person driving 60 miles per hour on a two-lane road, sending and receiving 19 to 27 text messages per minute, is that driving recklessly?
Absolutely.
Objection, Your Honor. The state has failed to certify that the witness is an expert in his field. She is a detective and not an accident research person.
Any response?
No, Your Honor.
Overruled.
What is your ultimate opinion of the day of the collision?
Objection, Your Honor. The state has failed to certify whether the defendant can make such an opinion.
Sustain. Rephrase.
Okay, thank you. Detective, in your opinion, would you say that texting and driving is reckless?
Objection, Your Honor. Calls for speculation.
Overruled.
Yes.
Thank you. Your Honor, I pass the witness.
Anything from the defense?
Detective Harper Miller. Would it be right to say, would it be right to have EMS examine all the individuals involved in the wreck?
Yes.
And in this case, you did not do that, did you?
I don't recall.
Do you recall taking a statement from Jordan?
Yes.
Did you take any measurements of the skid marks left from the vehicles involved in the wreck?
I don't recall.
Did you take any pictures of the accident scene?
I don't recall.
So without any pictures or accident or evaluations of the skid marks, you took a statement from Jordan Young, correct?
Yes.
And you still reached a conclusion that he was texting, right?
Correct.
Prior to this conclusion, did you have access to any phone records?
No.
But you still made the conclusion, since he's an 18-year-old kid, texting must be the logical choice, logical answer, right?
Yes.
Were you concerned that he may have had a medical episode prior to the wreck?
Objection, relevance.
Your Honor, it is relevant to prove that Jordan did not suffer from a medical episode prior to the wreck.
It's crossed. I'll allow it. Overruled.
At this point, Jordan was a citizen who got into a car wreck, correct?
Yes.
So he's entitled to your service and protection, right?
Correct.
But you weren't concerned he may have hit his head on something before the wreck or during the collision?
Not at the moment.
EMS did arrive before you, right?
Yes.
And when you got there, the first thing you did was take a statement from Jordan, correct?
Correct.
How was Jordan acting?
Nervous.
Your Honor, I pass the witness.
Anything on redirect?
Yes, Your Honor. Your Honor, no further questions at this time.
All right. May the witness be excused?
Yes, Your Honor.
All right. Detective, you are free to go. Thank you very much. Please call your next witness.
The state calls Dr. Angel Ramsey.
Doctor, please take the witness stand right here. And you may proceed.
Please tell the jury a little about yourself.
My name is Angel Ramsey. I have been practicing medicine for 18 years. I went to University of Houston University of Texas medical branch.
And how are you connected to this case?
I was the one that pronounced the gentleman dead.
Okay. And you stated that you got your medical degree at the University of Texas Medical School, correct?
Yes.
Objection, Your Honor, asked and answered.
Overruled. Move along.
How many years, and you said that you also practice 18 years in medicine?
Correct.
Okay. And have you been certified in emergency medicine?
Yes.
Thank you, doctor. Would you briefly describe Danny Walker's injuries to the jury?
Yes. Danny Walker had blunt force trauma to the chest, abrasions in both northern and southern extremities, and scrapes, bruises.
Thank you. Did you find any evidence of drugs or alcohol?
No.
In your professional opinion, the injuries from the crash caused Danny Walker's death, correct?
Yes.
Thank you, Dr. Ramsey. Pass the witness.
Cross.
Yes, Your Honor. So, have you examined people that's been in car accidents before, Mr. Ramsey? Yes. Okay. So, isn't it common when people get into these car accidents that they hit their head in something like maybe, steering wheel or a window?
Yes.
Okay. So, if you were on the scene, would you have wanted to examine everybody involved in the wreck?
I would suppose so.
And you would want to clear them of any medical episode that may have happened prior to the wreck, correct?
Correct.
And would you advise that the police officer let EMS examine anybody, everybody that's involved in the wreck before giving any statements?
Yes.
Taking any statements also?
Correct.
Okay. Would it be troubling to find out that the first thing that the police officer did was take the statement from Jordan without providing medical attention?
I suppose so.
I pass the witness, Your Honor.
Anything on redirect?
No further questions, Your Honor.
All right. May this witness be excused.
Yes, Your Honor.
All right, doctor, you're free to go. Thank you very much. Please call your next witness.
Yes, Your Honor. We call Logan Moore to the stand, please.
Logan Moore.
Yes.
Please take the, the witness stand, Mr. Moore. Or maybe not.
Your Honor, the defense would like to move for a directed verdict. The state wasn't able to prove the recklessness of the manslaughter. And the
Is the state ready to proceed?
Yes, Your Honor.
You may proceed.
Is your full legal name Logan Moore?
Yes.
Is your current occupation an electronics record manager?
Objection, Your Honor. Leading question.
Sustained.
Correct.
The objection has been sustained. Don't answer
Okay.
the question if there's an objection pending. Let's let the witness do the testifying.
What is your current occupation?
Recorder?
Is it correct to say that you've worked 5 years with the company?
Correct.
Is the company that you work at AGH Incorporated?
Correct.
Your Honor, may I approach the witness?
You may.
What I'm handing you is known as exhibits. It states Exhibit 4 for identification only. Can you please tell me what this is without getting in detail?
This is a recording of text messages.
Okay. Were the
objection, Your
record-
Honor. The state laid an improper foundation by not letting the witness identify the document.
Well, we're getting to that point, I assume.
Yes.
Overruled at this point.
Is the records contained in States Exhibit 4 made by or from information transmitted by a person with knowledge of the events or conditions
Objection,
recorded?
Your Honor. Compound question.
Overruled.
Correct.
Were these records made at or near the time of the events of the conditions records?
Correct.
Your Honor, the state tenders State Exhibit 4 for identification only purposes to the opposing counsel. Good.
Yes, Your Honor.
Okay.
We have no objection.
Okay.
State's Exhibit 4 will be admitted.
Your Honor, at this time, can I publish it
You
to
may.
the jury?
Objection, Your Honor. The state actually tampered with the evidence that's on there by publishing prior to this with writing at the bottom of the page that stated the text and that was sent when received.
All right, let's not show anything to the jury that hasn't been admitted or hasn't been established by the testimony of the witness.
Okay. What I am handing you is State's Exhibit 4 for identification only. Okay.
States 4 has been admitted. It is
Okay,
in
so
evidence.
that
Just
it
don't
is-
show the thing at the bottom
Okay.
of the page till you establish what that is through testimony.
Okay. Were these records made in a regular course of business?
Yes.
Okay. Mr. Moore, is the number 555-567-0078 Jordan Young's?
Yes, it is.
Objection. Oh, that's right. Yeah, go ahead.
What is the name listed on these records?
Jordan Young?
Would you please look at the records from September 9, 2017 at 2 p.m.? All the messages that began at 2 p.m.
Okay.
Okay. How many text messages were sent and received between 1:59 p.m. and 2 p.m.? Your Honor, I'm going to rephrase that question if that's okay with you. Were 23 text messages sent and received between 1:59 and 2 p.m.?
Yes.
Okay. At the time of the accident, did Jordan send and receive 27 text messages from 2 to 1 to 2:01 p.m.?
Yes, correct.
Okay. According to the records, what time did Jordan Young call 911?
At 2:01 p.m.
Okay. Did the frequency in these text messages increase between 1:58 and 2:01 p.m.?
Yes, it looks like they did.
Okay. Okay. Between 1:58 and 1:59 p.m., did Jordan Young send and receive 19 text messages?
Yes.
How many text messages would you say that it was in total?
Objection, Your Honor.
69.
Overruled.
Your Honor, I pass the witness.
Cross.
Yes, Your Honor. So, where are you currently employed?
I am currently employed at bear with me, Your Honor. AMG. I am currently
I'm
employed
sorry?
at AMG.
AGH, you mean?
AGH, yes.
Okay. So, how long have you been working there?
I have been working there for 5 years. 7. Five years, I'm sorry. 5 years, final answer.
Do you receive any professional training as an electronics records manager?
Yes.
Okay. How long was that training process?
I don't recall.
So do you have any of the records that states that, you know, the classes that you went through, the training?
I suppose so, but not at the moment.
So you can't provide those records for us today for the jury, correct?
No.
Okay. Now let me take you to the phone records. Now, is it normal for phone records to be increments of minutes and not seconds?
Yes.
Okay. So judging from these records, can you tell me if the text was open?
No, I cannot.
You cannot? Okay. So can you also tell me by looking at these records whether the text was, you know, a standard text message or if it was a voice text message?
No, I cannot.
You can't? Okay. And from these records, can you tell me if, you know, these messages, those were sent out, were they from a group chat? Can you tell me that?
No, I cannot.
No. Okay. So this very well could have been from a group chat from, you know, the same minutes, correct? Rather than, you know, what
Yes,
we're
it
seeing
could.
up here, correct?
Yes, it could.
Okay. So you cannot confirm based on the phone records that the text messages that were sent or received were from a group chat, correct?
No, I cannot.
Okay. So, you know, based on these records, can you show that Jordan's eyes were off the road?
No, I cannot.
No, you cannot. So is there any other information that we can kind of extract from these records other than that?
No.
No? Okay. So it could be possible that Jordan could have received the, you know, the text message the first 10 seconds of the minute and then 50 seconds later got into a car wreck, you know, correct?
I suppose so.
Okay. I passed the witness, Your Honor.
Anything on redirect?
No further questions, Your Honor.
All right. May Mr. Moore be excused?
Yes, Your Honor.
Thank you, sir. You are excused.
The state calls Jamie Davis.
Right here, Mr. David.
Thank you, sir.
I will remind you, you have previously been sworn.
Yes, sir.
All right, you may proceed.
What do you do for a living?
I am an accident reconstruction specialist and also a forensic engineer.
Sir, thank you. Is it true that you investigate and reconstruct the collisions?
This is correct.
And by doing that, you are able to determine if there are any vehicle damage.
Objection, Your Honor, leading question.
Okay.
Hadn't suggested an answer yet. Overruled.
And by doing that, you are able to determine if there are any vehicle damages or human injury sustained from this incident.
Yes.
Were you physically on site while investigating the collision?
Yes.
Were you able to inspect the condition of the highway?
Yes, I was.
Did you record this data?
Yes, I did.
And did you perform a collision and analysis?
That's correct, I did.
Do you prepare site drawings and determine pre-collision positions and movements of vehicles?
Yes, I do.
Okay. When did the collision occur on Highway 29 on Sunday, September 9th, 2017?
Yes.
Sorry, correction. On Saturday, Highway 29 on Saturday, September 9th, 2017.
Yes.
Thank you. Does this data allow you to determine the cause of the collision?
Yes, it does.
Was your ultimate collision that Jordan Young caused the collision by veering into oncoming traffic and hitting Danny Walker on his motorcycle.
That was my conclusion, yes.
Your Honor, may I approach the witness?
You may.
I am now offering into evidence Exhibits 1 and Exhibits 3.
We already have a state's 1.
Oh, it's the same one. Oh, one moment. This is just exhibit. The state offers Exhibits 1 and Exhibit 5 for identification.
Okay, we already have a 1.
Sorry.
State Exhibit 1 is a photograph of
3
Highway
and
29.
5.
3 and
Exhibits
5.
3
Okay.
and 5, yes, sir. Now, do you recognize this photo, and do you recognize the drawing?
Yes, I do. Both those are mine.
And in Exhibit 5, are the weather conditions of the highway the same?
Before we have any testimony from the exhibit, let's offer it into evidence and get any objections from defense.
Oh, yes. Let's see. And I tender Exhibits 3 and Exhibits 5 to the opposing counsel for any further objections. And furthermore, I offer it the Exhibits 1 and Exhibits 3 and Exhibits 5 for identification into evidence.
No objection, Your Honor.
All right, without objection, states Exhibits 3 and 5 will be admitted.
And Your Honor, may I tender this to the jury? May I show this to the jury?
You may publish it to the jury. All right, turn a little bit, straighten up. There you go.
Okay. And what is in your expert opinion, do you believe that Danny used all precautions necessary to avoid the collision?
Objection, Your Honor. The state has failed to certify whether the witness is an expert in this field.
I think he has been established as an accident reconstruction expert, but I will sustain the objection as leading. Rephrase your question.
Okay. In your expert opinion, what is your basis for the conclusion for what caused Jordan Young's collision?
Based on what I saw, the skid mark patterns show that Danny suddenly braked about 50 feet from the point of impact, which based on these skid mark patterns, tire marks, debris, it occurred in Danny's lane. Jordan didn't brake until after the impact. This is shown by another skid pattern made by Jordan's truck that begins west of the point of impact in Danny's lane and continues for an additional 100 feet, ending in Jordan's lane. So Danny saw Jordan's truck veer into the eastbound lane and applied the brakes in an attempt to avoid a collision.
Okay. In correlation with your response, do you believe that Danny used all precautions necessary to avoid the collision?
Yes, I do.
Based on your analysis, was Jordan watching the road at the time of the collision?
No, I do not believe so.
And in your expert opinion, would Danny still be alive if Jordan was watching the road instead of his phone while driving?
I think he would be, yes.
Thank you, Mr. Davis. Pass the witness.
Cross.
Yes, Your Honor. Mr. Davis, isn't it true that you're not a medical doctor?
That is correct.
And isn't it also true that you have no knowledge whether Jordan suffered from a medical episode prior to the wreck?
That is correct.
Okay. And is it true that you just testified and said in your expert opinion he was not watching the road, correct?
Correct.
When you say that, you don't mean to imply that he was being reckless. It easily could have been from a medical episode or some other factor, right?
I don't believe I implied anything.
Okay.
In my opinion, it didn't seem like he was watching the road.
Okay, so it could have been a medical episode.
It could have been a number of things, yes, sir.
Your Honor, I pass the witness.
Anything further on direct or from the state?
No further questions, Your Honor.
All right. May this witness be excused?
Yes, Your Honor.
All right, sir, you are free to go. Thank you very
sir.
much. Anything further from the state?
No, Your Honor. The state rests.
State rest, all right. All right, ladies and gentlemen of the jury, that means you have heard all the evidence you were going to hear from the state. We will now go into the defense case in just a moment, where we will take a short break for 10 minutes. So please be back in the jury room in 10 minutes.
All right, Mr. Jury.
All right, please be seated. Is there anything from the defense?
Yes, Your Honor.
Yes, Your Honor. The defense would like to move for a directive verdict. The state has failed to prove all elements of manslaughter in their argument. They have failed to prove that Jordan was acting recklessly by not disproving he had a medical episode or any other blackout prior to the wreck.
Any response from the state?
Your Honor, objection. Jordan having a medical condition is not one of the elements that needs to be proven in the indictment.
Your Honor, this is not one of the elements, but when the state says that texting and driving is the sole cause of this accident, they have the burden to prove that it wasn't anything else, and they have failed to do that.
All right, the test is whether there is a scintilla of evidence for which the jury could come to a conclusion that the defendant committed the offense. Between the testimony of Mr. Moore and Mr. David, I believe there is enough for the jury to conclude that this was an accident caused by the negligence or the conduct, wrongful conduct of the defendant. So the motion for directed verdict will be denied. All right, are you ready to proceed?
Yes, Your Honor.
All right, let's call the jury back in, please.
All right, Mr. Jury. We got one in the rest.
Okay. There's always one. You may be seated, ladies and gentlemen. Not the jury, not the audience, the jury. Please remain standing for all the jury. All right, now you may be seated. We'll wait for the last juror. All right, please be seated. And defense, call your first witness.
Yes, Your Honor. The defense calls Jordan Young to the stand.
Mr. Young, please come up and take the witness stand. I will remind you that you also have been sworn and are presently under oath. Take a seat. And you may proceed.
Please state your name for the record.
Jordan Young.
Hello, Jordan. How old are you?
I'm 18 years old.
And do you go to school?
I do, yes.
Where do you go to school?
I go to Clear Falls High School.
Okay. What grade level are you in?
I am a senior in high school.
Do you participate in any extracurricular activities?
I am in the Clear Falls band.
Okay, great. What instrument do you play?
I play the euphonium.
Oh, that's awesome. Let me see. Are you involved in any other clubs around school or?
Yes, actually, I am the vice president of the student body.
Oh, great. Do you plan on going to college?
I do, yes.
Where do you want to attend college?
I've always wanted to go to University of Texas at Austin.
Okay, great. That's a really good school. What do you plan to major in?
I've always wanted to major in video game design.
Okay, that's interesting. How long have you been interested in video games?
Ever since I was a kid, I fell in love with it. Whenever I saw my brother playing it, it's been my passion for a long time.
That's awesome. That's awesome. I wish you luck in that, Jordan. Let me see. Jordan, how old were you when you got your license, your driver's license?
I was 16.
Okay, and how long have you been driving?
2 years.
Now, Jordan, I'm going to take you back to the day in question, the day of the wreck, September 9th. All right?
Okay.
Where were you going that afternoon?
I was headed home from my girlfriend's house.
Okay, from your girlfriend's house. How long have y'all two been dating?
We started dating freshman year of high school.
That's great. Jordan, what were you doing before the accident?
I was texting in a group chat.
Okay. How were you texting?
I was using voice to text.
Voice to text. What is voice to text?
It's this option on the phone where if you speak into the phone kind of interprets what you say and then sends that message over text.
And why do you choose to text that way?
It's hands free. I can keep both hands on the wheel and my eyes on the road. It's much safer.
Okay. Are there any other features on the phone that you use?
I do use text to speech sometimes.
Text to speech.
Yeah.
What is text to speech?
It's this program on my phone where it reads aloud the text messages whenever I'm sent them. I use it a lot. It's nice.
So you don't have to touch your phone at all?
No.
Okay. On the day of the accident, how were you texting?
I was using voice to text and text to speech on a group chat.
Okay. So you were using voice texting and in a group chat.
Yes.
Prior to the accident. Okay. What did you do after the accident?
It was all. I knew I hit something. I stopped the car immediately, and I was frozen there. I didn't know what just happened. I was horrified. I stood at the wheel for a second. I looked around, made sure I was okay.
Right.
I was frozen there. I checked, make sure I was okay, and then I called 911.
Let me take you back to that previous question, Jordan. You said you were group texting. What is group texting?
It's just it's a bunch of people in a group chat that can talk to each other, and it's all my friends and my girlfriend is in it. And,
So when you're texting in the group chat, you're receiving numerous texts all at the same time.
Yes.
Okay. Jordan, how did you feel after the accident?
I felt horrible.
Objection. Sorry. The facts are not in the evidence that it was proven to be group messaging.
Jordan never clarified.
No, we're past that. That asked and answered. Overruled. Move along.
How did you feel after the accident, Jordan?
I felt horrible. I saw that I hit somebody, and I felt like a monster. I saw that there was a motorcycle, and I was thinking that there had to be a person on it, and I was thinking about his family and everybody that would be affected, and I didn't know where he was. I kept thinking, the more and more I thought about it, I thought, I'm a monster. I felt horrible. It was felt bad.
Absolutely.
Horrible.
Your Honor, I pass the witness.
Cross-examination.
Jordan, have you ever received a learner's permit?
I have, yes.
So then it's safe to say that you've taken the learner's permit course?
Yes.
Do you currently have a driver's license?
Yes, ma'am.
So then it's safe to say that you've taken the driver's education course?
Objection, Your Honor. Asked and answered.
No, Your Honor.
The driver's license.
Are you talking about two different courses?
Yes, two different courses.
All right, overruled.
Okay.
Yes, I have taken the driver's license.
Okay. Do you recall learning in these courses that texting and driving or even talking on the phone is dangerous?
I believe so, yes.
So then it's safe to say that you've learned that they advise you to pull over when you are texting and driving, correct?
Yes.
How long have you been driving for?
2 years.
How long have you been with your girlfriend?
Objection, Your Honor. Asked and answered.
It's cross. Out loud. Overruled.
3 years now.
Have you driven to your girlfriend's house multiple times?
Yes, yeah.
And these multiple times, did you take Highway 29?
I believe so, yes.
Do you know how many times?
No,
Objection, Your Honor. Irrelevance.
No. Yeah, Your Honor, it's proving the familiarity with the highway.
Cross-examination. Out loud.
So then it's safe to say you're comfortable with Highway 29?
Yes.
Have you ever voice texted before?
I do it all the time, yes.
So then it's safe to say you were comfortable with voice texting and driving?
Yes.
So then it's also safe to say that you're familiar that Highway 29, the speed limit is 60 miles per hour?
Yes.
Would you agree that voice texting is still sending a text message?
Yes, yeah.
Would you agree that any form of distraction is unsafe, including one where you are talking on the phone or listening?
Yes.
Were you aware of the risk to voice text while passing other motorists on Highway 29?
I am, and that's why I use voice text. It's much safer.
In the statement that Detective Harper took of you, you said that you didn't know what happened, correct?
Yes.
You also said in your statement that it was dangerous to look down at your phone and not keep your eyes on the phone, correct?
Mm-hmm. Yes.
I want to take you back to September 9th, the day that the accident occurred on Highway 29.
Okay.
You stated that you received several different messages and from different friends and your girlfriend, correct?
Yes. In a group chat, yes.
Okay. You said earlier that you did learn that pulling over and answering or responding in your driver's education course. So then why did you not pull over?
It was in a group chat and they were sending them to me. There wasn't much I had to respond to. And if it was a response, it was very limited answers, like just 2-letter answers or just limited.
Okay. So you responded using voice text to these messages?
I did, yes.
In order to know who texted you, you said in your statement that you had to look down, didn't you?
Objection, Your Honor. Jordan did not say that in his statement. He said he had to look at his phone to see who texted.
Well, the statement is not in evidence.
Your Honor, may I refresh the defendant's memory by showing him his statement?
You may.
Jordan, what I'm handing you is your statement.
Okay.
Okay. Earlier I asked you, in order to know who texted you, you had to look at your phone. Did I?
Yes.
Can you refresh your memory by reading your statement, please?
Mm-hmm. Mm-hmm. Yes.
Okay. Okay, so I'm going to re-ask you the question. Is your mind refreshed now?
Yes.
Okay. So in your statement, you said you had to look down to see who sent you the messages, correct?
Yes.
And in order to know how to respond to those messages, you had to read them, correct?
Yes.
So you looked down at your phone, correct?
Mm-hmm.
Is that a yes?
Yes. It was just I glanced at it. Yes.
Would you consider this still looking away from the road?
No.
Why?
It was on my dashboard. It wasn't in my hand. I had both hands on the steering wheel. It was on my dashboard, and it was just a glance. It wasn't for any significant amount of time, milliseconds.
So you looked down, you looked up at your dashboard.
Objection, Your Honor. The statement never said you looked down.
That's not the question. The question is not about the statement. The statement is just, or the question is just a straightforward question.
Okay.
Overruled.
Okay. So you were looking at the phone and the road at the same time?
No, I looked down for, like I said, a millisecond, and then I looked straight back on the road.
So then you admit that you didn't look at the phone for a second?
It was a very limited amount of time. I don't recall specifically how long, but it was not very long at all.
Okay, so then right here, look at this one. Okay. So you told the jury at the time of the collision you were watching the road and driving like normal, didn't you?
I don't recall saying that.
No.
Yes. Yes,
Okay.
I did. Yes. Sorry. Yes.
And you did say you weren't looking at your phone, correct?
Yes.
But you did say you had to look at it briefly, correct?
Yes.
Yes. Okay. Earlier you said that you kept you kept your eyes on the road and on the phone at the same time. How come you didn't see Danny Walker?
I don't know. I don't recall. I can't remember. It's all kind of blurred together for me now.
So you didn't see a motorcycle on the other lane?
I don't remember. I can't answer.
Did you see the view of the road ahead of you when you were driving?
I don't remember. I think so, yeah. It's not a memory I like reliving.
So you did not see Danny Walker when you were looking at the road?
I don't remember.
You said in your own testimony that you called 911 immediately after the collision, correct?
Yes.
Okay. You also heard Logan Moore testify that you sent and received 27 messages between 2 and 2:01 p.m., didn't you?
Yes.
So it's safe to say that you were sending and receiving 27 text messages around the exact time of the accident, correct?
No. I received them, but it was in a group chat, like I said, so it was multiple text messages coming in at once from.
But you did respond, didn't you?
I don't recall.
How many did you respond to?
I can't remember that. I didn't count.
Why didn't you pull over to respond?
I didn't. I don't know.
Your Honor, may I approach the witness?
You may.
Jordan, what I'm handing you is the phone call records.
Okay.
Here you go. Do you see your phone number on them?
I do.
What's your phone number?
0078.
Your Honor, I offer this to the opposing counsel as Exhibit 6 and 7 for any objections. And
No objections, Your Honor.
Your Honor,
All right.
I'd like to
With that-
offer this into
Without
evidence.
objections, states 6 and 7 will be admitted, and we've only talked about one. What are these records? What are 6 and 7?
These records are his phone records of his texting before the accident and during the accident and after the accident.
So these are different than those in State's Exhibit number 4.
Yes, sir.
Okay, then they are admitted, and yes, you may question him from
Okay, I'm going to leave these with you.
2-minute warning.
Okay. Earlier, the defense said that you had a medical condition. What is this? of your what was your medical condition?
Objection, Your Honor. The defense
Yeah.
never said he had a medical episode, that it was a possibility that the state failed to disprove.
Sustain, rephrase.
Do you have any medical conditions?
As a kid, I used to kind of get these blackout episodes, but with my mom took me to the doctor and I got some medication for it. And I take it to not have them.
So you were aware of your medical condition and you still chose to text and drive, correct?
I have medicine for it.
But you still text and drove?
Yes.
Did you have an episode while you were driving?
I don't know.
No further questions, Your Honor.
Anything on redirect?
Yes, Your Honor. Jordan, where was your phone in the car?
It was in a clip that was in an air vent where I don't even have to touch it at all. It's in there.
So you glanced at it, but didn't look down, right?
No, it was glance.
Okay. And Officer Miller took your statement, right?
Yes.
Did you sign any forms of paper that waived your right to remain silent?
No.
Did you sign the statement that you gave?
No.
No further questions, Your Honor.
All right, anything on cross?
No further questions, Your Honor.
All right, you may step down, sir. Anything further from the defense?
Yes, Your Honor. The defense calls Justice Lewis to the stand.
Justin Lewis?
Justice Lewis.
Justice Lewis.
Yes, Your Honor.
All right, sir, have a seat. I'll remind you you're under oath.
Yes, sir.
And you may proceed.
Mr. Lewis, did you conduct your own personal?
Whoa.
Oh,
He's their witness.
okay.
Please state your name for the record.
Justice Lewis,
What is your occupation?
I'm a behavioral analyst.
Can you please explain what that is?
It's a study of human behavior, reaction times, different effects on different types of stimuli.
Okay. And how long have you been in this field, Mr. Lewis?
Say about 30 years.
Okay. And you did go to school for this, correct?
Yes, I attended Duke University, obtained a master's in experimental psychology.
Oh, okay. So you got your degree in it, correct?
Yes.
Okay. Have you published anything?
I've been published 8 times.
Oh, okay. Have you received any awards?
Received the President's Fellowship,
Okay.
1971-70.
No. Have you ever testified in Texas courts as an expert witness before?
I've testified 400 times in criminal and personal injury cases.
Okay, well, okay, great. Your Honor, I'd like to certify that Justice Lewis is an expert in human factors engineering. And so now let me take you back to September 9th of 2017. Did you evaluate that wreck?
Yes.
You did? Okay. Now, based on your professional opinion, is it possible for someone to have been watching the road and not applied their brakes until after the impact?
Yes.
I passed the witness, Your Honor.
Cross.
Thank you. How many times have you given expert testimony in trial?
About 400 times.
And how many of those times have you testified for the defense?
I really wouldn't have that number with me.
Your Honor, may I refresh the witness's memory of his statement?
Has he given a statement?
Did you give a statement to the?
Yes.
Okay. Your Honor,
Who'd you give a statement to?
To the detective?
Yes.
Okay. So, Your Honor, may I refresh the witness's statement?
Well, the way you do it is ask him if he recalls giving a statement.
Okay.
Ask him if he recalls what he said. If he doesn't, then you can refresh his memory.
Okay. Do you recall giving a statement?
I do recall giving a statement.
Okay. And do you recall in your statement stating how many times you have testified for the defense?
I remember that it was brought up, but I don't remember the exact number I provided.
Okay. Your Honor, may I refresh the witness's memory?
You can show him his statement.
I'll move on to the next question. Based on your expertise, is it possible that Mr. Young's reaction time is explained by the fact that he wasn't watching the road?
His reaction time would be based off speed traveling and other factors as far as things that would draw his attention.
Okay. Would you agree that an ordinary person would keep their eyes on the road at all times, no matter the circumstance?
And since we have that as a question, we do not have an answer. Anything further from the defense?
No further questions, Your Honor.
All right, may this witness be excused?
Yes, Your Honor.
All right, so you're free to go.
Thank you.
Anything further from the defense?
No, Your Honor. No further questions from the defense. Defense moves to close.
All right, does the defense rest?
Yes, defense rests.
All right, are we ready to proceed with closing arguments?
Yes, Your Honor.
This time, take your seats. This time, ladies and gentlemen, I will read to you the charge of the court. It contains definitions, instructions, and elements of the law for you to use in reaching a verdict. Don't be daunted by all the legal stuff in it. You'll have the original when you go back to deliberate. It'll just give you an idea of what the attorneys are going to be arguing when they get up to do their closing arguments in just a moment. 17 CR 9711, State of Texas versus Jordan Young, charge of the court. Ladies and gentlemen of the jury.
I'm sorry, Your Honor, but we have a break before closing.
All right, we have been asked to have a break. Let's take a 10-minute break. I knew we were moving fast. All right, we will stand adjourned for 10 minutes. No. Oh, okay.
And I forgot to check the charge. I'm hoping it says Hawk County instead of Harris County in the charge. If it doesn't,
Doing direct, you tended to try to do the testifying, so that makes
I think I need a lot more stuff.
didn't notice what time we went to break. Are we getting close or no? I apologize. If you'll just holler at me when you're ready, and I'll turn the mics back on. So. All right, jury ready? Let's start getting everyone seated, please.
All right, for the jury.
Yeah, this part I got.
All right, please be seated. All right, I will begin reading the charge again. Ladies and gentlemen of the jury, the defendant, Jordan Young, stands charged by indictment with the offense of manslaughter, alleged to have been committed on or about the 9th day of September AD 2017 in Hawk County, Texas. To this charge, the defendant has pleaded not guilty. Our law provides that a person commits the offense of manslaughter if he recklessly causes the death of an individual. A person acts recklessly or is reckless with respect to the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. Individual means a human being who is alive, including the unborn child at every stage of gestation from fertilization until birth. Now, bearing in mind the foregoing instruction, if you believe from the evidence beyond a reasonable doubt that on or about the 9th day of September AD 2017 in Hawk County, Texas, the defendant, Jordan Young, did then and there cause the death of Danny Walker by being aware of the risk of hitting another vehicle if he was not watching the road, and by disregarding that risk when he read and responded to text messages while driving, which is a gross deviation from what an ordinary person exercising ordinary care would do under the same circumstances, then you will find the defendant guilty of manslaughter as charged in the indictment. But if you do not so find, or if you have a reasonable doubt thereof, you will find the defendant not guilty. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to their testimony, but the law you must be governed by you shall receive in these written instructions. After you retire to the jury room, you should select one of your members as your foreperson. It is his or her duty to preside at your deliberations, vote with you, and when you have unanimously agreed upon a verdict, to certify to your verdict by using the appropriate forms attached hereto and signing the same as foreperson. Your sole duty at this time is to determine the guilt or innocence of the defendant under the indictment in this case, and restrict your deliberations solely to the issue of guilt or innocence of the defendant. Following the argument of counsel, you will retire to consider your verdict. Suitable forms for your verdict are hereto attached. Your verdict must be in writing and signed by your foreperson. I have signed as the presiding judge. Attached to the charge is a verdict form. Gives you two choices. The top line says, "We, the jury, find the defendant Jordan Young guilty of the offense of manslaughter as charged in the indictment." Signature line for your foreperson. Under that, "We, the jury, find the defendant Jordan Young not guilty," and a signature line for your foreperson. As I said, you will have this when you go back to deliberate. At this time, I'll recognize the state for closing argument.
Ladies and gentlemen, mothers and fathers, sisters and brothers, you have heard the facts, the evidence, and the testimonies of all the witnesses here today in this case. Now, as you consider the evidence, I would like to ask each of you for one favor. Don't forget Danny Walker. He wasn't just a victim in this case. He was a brother. He was a son. And if it weren't for the acts of the defendant, he could have been much more. His life was stolen from him because of the recklessness of this man. Who allowed himself to be distracted by his phone from messages from his friends and from his girlfriend. Messages which he must have believed were more important than the safety of all those who traveled on the road with him that day. And because of this choice, Danny Walker's life is now over, is ended. He will no longer graduate from prom. He will never find a first love. He will never get married. Dead is dead. His loved ones are not going to suffer any less simply because the defendant didn't intend on killing someone that day. His indifference to the consequences of distracted driving must be addressed. If a man was blindfolded and openly shooting a gun and he shot someone and killed them, he can't say, well, I didn't intend on hurting someone that day. The matter of the fact is that he shot and killed someone because of his reckless use of a weapon. Under the Texas state of law, we only must prove that he had an intent to drive a motor vehicle that day, and doing so recklessly, and because of his recklessness, caused the death of Danny Walker. You must have your eyes on the road at all times. We all learned this, and as the defendant even stated himself, we all learned this in driver's ed, that texting and driving is very dangerous, and that it needs to be addressed. And perhaps you feel sympathy for the defendant. He is young, but there must be consequences for his choices and for his actions. If you do not convict, you are giving others permission to continue to drive while distracted by their phones, while texting and driving, and in return, more lives will be lost. A weapon can be a car. If a vehicle is used recklessly, it can be turned into a weapon that can and will kill. How many more children need to be taken away from their parents for something to be done? How many more children need to be taken away because of distracted driving, because of texting and driving? There must be consequences. What you say about your verdict of Jordan Young will serve as an example to the communities, will serve as an example to the younger generations, that texting and driving, that distracted driving can and will kill, that it is very, very dangerous. Your verdict can be a part of the change. Your verdict can and will save lives. Your verdict, based on the evidence of this case, must be guilty. Thank you.
All right. Closing from the defense.
I cannot even begin to imagine the heavy, horrible burden that Jordan Young has had to carry with him since the day of this accident. Jordan Young, he will never forget the sound of metal on metal colliding. He will never forget the feel of the abrupt stop when two vehicles collide. He will never forget that emptiness in his heart when he found out this resulted in the death of a young boy. Jordan was scarred from this, and it will stay with him for the rest of his years. Now, it's no question that the death of Danny Walker is a horrible, horrible tragedy. And I offer my full condolences to the Walker family, because no family should have to be going through what they're going through now. A young boy was taken from us, and now another young boy's future is about to be stripped away from him if you convict him today based on an accident. The state has the burden of proof, so they must prove to you beyond and above all reasonable doubt that the accusations they have against Jordan Young are correct. They did not do that. The state has failed to provide evidence. The state has failed to provide evidence that proves that that Jordan Young did not suffer from a medical episode. They have failed to address the fact whether he had a blackout, an anxiety attack. When they say texting and driving was the sole purpose of this wreck, they have to prove that it was only texting and driving and nothing else beyond a reasonable doubt, which they have not done. Another thing that the state has not proven is whether or not a text message was sent or received at the exact moment of impact. This uncertainty is reasonable doubt. This is because the phone records only provide you with a 1-minute window time, which means it's literally impossible to prove whether a text was sent within the first 30 seconds of the minute or the last 30 seconds of the minute, or the first and last 20 seconds of the minute, first and last 10, so on, right? This means it's very much possible that Jordan received a text at 2 p.m. and then 50 seconds later got into the wreck. And this possibility, this gray area, ladies and gentlemen, is reasonable doubt. This proves that the state has failed to meet the burden of proof, and that the accusations they have against Jordan are wrong. If you convict him today, that means any one of y'all can leave this jury room, can leave this court, be driving home, click send a text at 7:30. 30 seconds later, you get into a car wreck. Well, the records are going to show you were texting at 7:30, right? That's when the wreck happened. And then what? You're going to be sitting where Jordan is looking at a felony? No. That's injustice. I challenge the state to answer these questions. Why did Detective Miller go straight for the statement and not provide Jordan with medical attention first thing? Why did Detective Miller reach conclusions without looking at proper evidence first? These questions will be left unanswered. You can't convict someone on unanswered questions. When you return to the deliberation room, I beg you, ladies and gentlemen, I beg of you, if you have any doubt in your mind at all, the slightest bit of doubt, deliver the right verdict and find Jordan not guilty.
Thank you. Rebuttal from the state.
Thank you. Our intention is not to dispute whether or not this incident was an accident, only to prove that it was caused by Jordan's recklessness, as stated earlier. Every message sent at the time that he was driving is illegal. That's just a fact. Any group messages sent is still a message sent. Whether or not if it was a group message or an individual message, the incoming messages are distracting, is a type of distraction, as well as reading the messages, having to read multiple messages and then respond is reckless. A disregard for the law is a disregard for the law. Period. And as the state further stated in as the defense further stated in the beginning of the trial, that we should look at it as a microly look at it, not macro. So just basically look at the small picture, not the big picture. And that we're going to try to prove to look at the big picture. And yes, I agree. I definitely agree. The state agrees that we should look at this as a bigger picture. Because your verdict, if you convict Jordan Young, will, in the long run, save lives, as I stated before. Thank you.
All right, ladies and gentlemen, you have now heard all the evidence, been read the court's charge. You've heard the closing arguments of the attorneys. It is now your duty to go and deliberate on guilt or innocence. We will await your verdict. All right, Jerry. Please be seated.
Your Honor?
Yes.
Will the witnesses be released?
Yes, the witnesses may be released from the rule.
All right, thank you.
Yes, ma'am. How are you? Good to see you again. tell you that every year. I've done this now, I think, 3 years, 4 years. You have to go through law school, college and law school, and get some experience to be able to try cases. And y'all are still in that very infant stage. So, with what you know and exposure, y'all do a really, really, really good job. Just some things as we go through. The state, you got to read the indictment, but what does it say at the very top? In the name and by the authority of the state of Texas. And you didn't read that. You want the jury over there to say, man, this is serious. And then the final line, you always say, against the peace and dignity of the state, signed by the foreperson of the grand jury. You want them to think that this is gold. You know, that this has been looked at. The grand jury has done its job. So don't just read just the meat of the thing. Give them the full against the peace and dignity and all that good stuff. Let's see. You said, Ms. Monis, you were starting, Danny took care, Danny actually came to a stop and was actually struck at 60 miles an hour. And I thought, she just said the defendant, she meant to say the defendant did all these things. But see, that so stood out from what turned out to be the case. You should have given me and the jury more, because they were probably wondering, what did she say? Just keep that in mind. It seemed a little strange. Danny actually came to a stop when he saw it was going to happen, and still got hit by the defendant at 60 miles an hour. He went flying through the air, et cetera, et cetera. Just saying, you did a really good job as an opening. Always, as a defense, you want the jury to start thinking of reasonable doubt. And you said lots of unanswered questions. They're going to come up way short of beyond a reasonable doubt. Exactly what you have to do. The very first thing. Beat on that point. They haven't met their burden. They haven't met their burden. You went a little bit too far and said beyond all or any doubt, and that's not the law. And they could have objected, but you got by with it. Oh, when you, this bonus, when you had the defendant identified, you did okay, but you want to make sure that everybody knows exactly. The gentleman over here in the blue shirt with the tie sitting next to the two lawyers who are going to try to confuse you. You know, you want to imply that. And make sure that you understand, he has identified the defendant. Now, don't short circuit your theatrics. What do you, half the reason we do what we do is for the theatrics. So we do the theatrics. Okay, you went through some weasel words about what, in your opinion, and based on, et cetera, calls the accident. Tell the ladies and gentlemen the truth. What happened? He was driving, looked at his text, didn't pay attention to what was happening, and he caused this accident. Don't go off in a bunch of flowery language. What happened? Okay. Mr. Rutledge, you did real good on the cross of the detective. You got to, don't recall. Did you do this? No. Were there skid marks? I don't recall. Were there pictures? You take pictures of the scene? I don't recall. That's what cross is. Cross-examination is surgery. You don't know what you want from a question, you don't ask it. You better know the answer when you ask it. And if there's nothing that you want to get from that witness, you don't really even need to ask it. But you got that, you showed it to the jury. The detective didn't take photographs, didn't take, measure the skid marks, etc. First thing he did was go and take a statement of Jordan. He didn't call him the defendant, Mr. Young, he called him Jordan. And as a defense, you want to personalize your client. You want the jury to think of him as Jordan, or Bob, or Bill, not as the defendant, or Mr. Young. And so it's very good to refer to him in that way. It gives them, liking you, it gets them thinking of him as a person, not as a monster who's killed a guy. So that was very good. say blunt force trauma, what does that mean, doctor? You know, again, this is not the thing where you've got an hour to cross-examine or turn on all the medical evidence, that kind of thing. But you want a little more than that. When you say blunt force trauma, what happened? His head was crushed. He broke his legs. He flew through the air 100 and some odd feet, you said. But describe or tell the jury and the doctor, may not have known given your script and the circumstances you're under. In real life, you always want to tell the jury what it was. Have you all heard that program I give them, persuasive speaking? A couple of you have. You know, the things you want the jury to see and hear. You don't want to talk about blunt force trauma. You want to talk about blood and guts, broken bones, bleeding, those kinds of things. Ask Ms. Weber and I'll come give it again for you. Okay. What the heck is AGH? Nobody ever said what it is. Who is your employer, AGH? What is this exhibit? It's a recording. You did okay proving up the medical records, but you want when you're giving them some evidence, you want them to know what it is. It's golden. This is the list. This is this. The reason I'm bringing this to you, ladies and gentlemen, is because it settles the case. It proves guilt. Exactly what he was doing. Yes, occurred at 2 p.m. Nobody ever said, sunny? Is it raining? What was going on? And a little bit later then, when you get to questioning, I think you came close on a good question. You need to get a little bit further. But again, what is this AGH thing? Okay. Not all the jurors are going to be 20-something millennials. You're going to have a bunch of people that are 70 years old on your jury panel or on your jury. They don't know what a group chat is. They don't know all these things. What is a group chat? It's a short, easy question. Get them to explain. It's 4, 5, 6 people long. Even little ladies have the ability to text their grandkids. But you want them to understand what a group chat is. And that's how there could be 20 or 30 messages on there. You guys really should have done that because you've got to explain why there's so many on there at that point in time. The drawing of the scene from your accident reconstructions, again, in the real world, you want him to get up or have a laser pointer and talk and discuss and show the skid marks. But it's a little confusing, and that's where I finally realized that you were not wrong when you said what you said at opening. That's what happened. The guy was driving, came to a stop, skid marks, but you want to milk that and talk a lot more about your exhibits. And in general, if you're going to introduce something, you're going to have an exhibit, show it to the jury, use it. Use it. Then Ms. Roach, you got I think it was J.Y. that's all I wrote down. Defendant, okay. Hey, you introduced him. How old are you? Where do you go to school? What are you in? You in the band? Oh, that's great. Now, all the time you were saying this, you kept saying, oh, that's awesome. Oh, I wish you luck in doing that. Y'all won't let him get by with that kind of stuff.
Yeah, we were looking at it, but we didn't know what it was.
Yeah. Hey, I object to the sidebars. Let him ask a question, but we don't want the lawyer telling everybody how awesome it is that he plays in the band. College plans, etc. That's a really good introduction because, again, you want to personalize it. You want that jury back there saying, do we convict this monster or do we let this nice young man who did something wrong go? You want it that way. You want to be hands-free, much safer, all that came out real good. And then finally, someone defined what group chat was. I did write that down. The bonus you got him to say, text is a text, voice is a text, regular text, a text is a text. The indictment says he was texting. That's a good point. All right, the way it works with recorded statements, and we were playing fast and loose. With that, I can see Ms. Weber the way it works, if it's something like a deposition or been proven up by evidence, say where they've taken a statement of the defendant, you ask the question. What was it you asked? Were you looking at the road? And then depending on what his answer is, you say, well, have you testified in a different way before? Have you said something different? Haven't you said no before? And if he then says, well, yeah, I did. That's as far as you can go. You have impeached him by the fact that he has said, I have given a prior inconsistent statement. But if he denies it, then you can say, let me show you, and then you can use the statement. It's a lot more fun in a civil case because you'll have a deposition. In a criminal case, you're a lot less limited, or a lot more limited. But it's like, didn't you say, and then of course you milk it. You were in, it's a civil thing, it's a deposition. We were in your lawyer's office, and we told you, even though everybody rolled up their sleeves and it was all informal, that you needed to tell the truth and all that. And then you impeach him with what he said. And then Bruce Martin blow it up, put it on the Elmo, or the overhead projector for closing argument, to show that he's changed his story. But then you said, wait a minute, didn't you tell the jury a minute ago you were looking at the road? And then you said, and you had him go in a couple different ways. In fact, I wrote over here, backing and changing and wiggling. He was having to kind of fill in a little bit. And so then you said, so why didn't you see Danny Walker? Really good question. He didn't have an answer for that. That's where you needed to tie in that sunny day, and again, cross sometimes because you can lead, you can do the testifying. So you were looking at the road. That's what you told this jury. Yes. And so tell the jury, ladies and gentlemen of the jury, what the weather was like that day. If you look at it, well, it was bright and sunny. Bright and sunny. So tell the ladies and gentlemen of the jury, what was it that prohibited you or prevented you from seeing this guy on a motorcycle? You know the answer. You control the cross-examination. Like I said, it's surgery. You set it out. You make him be the one to go out on the limb and saw it off. Oh. From the first, they're talking about a medical episode. There's no testimony about medical episodes whatsoever. He gets on the stand on direct, and there's no, and then you say, did you have a medical episode? I'm trying to convict you, so please tell me the answer to a question so the jury will find you not guilty. Why would you ask that question? If they didn't, and if they did it on redirect, then you can say, well, after my cross-examination, they realized they had to come up with something. But they didn't ask him about medical episodes, so why give him the ammunition to argue to the jury? He may have had a medical episode. And then he gets up and says, objection. We didn't say he had one, we just said it could have been. We didn't really think he did. We're just trying to throw something out there for the jury to hang their head on. And when he said that, you just said, so, did you, once you got to that point, but you should never ask him that question. All right, then in closing, Ms. Vera, you said the only thing we had to prove was that he had an intent to drive. Don't give yourself an extra burden. You don't have to prove an intent. He was just driving. You don't want to. They could get up and say. You said don't be swayed by the fact that the defendant's young. But then you should have drawn more conclusions or tied that closer to Danny. Don't feel sorry for the fact that he's young. And you said don't forget about Danny. Danny Walker is young. Danny Walker, blah, blah, blah. Go a little bit more on that. Examples of community, every DA argues that in the closing. Whoever knows that. Send a message to the people of Galveston County or wherever, Hawk County, that we're not going to tolerate this. Some of the best arguments, they'll walk over and they'll point their finger at the defendant. It stops here. Again, your own Texting is illegal if sent. There's never any evidence texting is illegal. You should have objected. There's no evidence of that outside the record. You know, it's never there. But you got by with it. So yeah, y'all did great. It was wonderful. I enjoyed doing this. I'll do it anytime you ask me. Y'all are going to be good lawyers someday, I hope. Love to see you in my court at some point in the future. Any questions, thoughts, comments? I like that you did your closing without reading or notes. You knew what you wanted to say. And that's a big part of trying a case is don't get so tied to your notes or to what you're doing that you aren't listening. Because you'll get some wonderful, wonderful nuggets, either from the witness stand or from your opposition. You know, we didn't say it had an episode, we just said it could have been. You want to milk that. So listen. You know, always got to be listening. Don't get tied to a checklist. Don't get tied to your notebooks. Don't get tied to things like that. Because trial is a fast-moving deal, and you never know what's going to come out, what's going to happen. But you did a good job. All right. They're taking a heck of a long time. We may have a hung jury here.
Oh no, we've got till 7, Judge.
Oh, okay. Lord.
That's a joke.
Well, we'll do punishment. And just FYI, next week I'm trying a capital murder case with a defendant strangled his girlfriend, and she was pregnant and caused the death of her and the fetus. We got a dual capital murder case. Non-death, thank God. It starts on Tuesday.
Okay.
You want to come see it? You're welcome.
You can sit in on this?
Sure. Oh, it's public court. Yeah.
So this is the 110th district, is there?
10th district. Yeah. Yeah. Full court out on there.
Judge, what do you think about our spur of the moment witness here? Twice.
Twice. He knew he was on stage. He did good.
He did good. And our defendant actually is ironic because in the script, the defendant was 18 and the decedent was 17. But our defendant here turned 17 about less than a week ago. A couple of weeks ago.
You
He's
did very
barely
good.
17.
Very good. I like you as a witness.
Isn't he wonderful? Yeah.
We prepped him well.
Good. Good. Good.
He's a bright person. And he missed band practice to be here. They're in UIL. They have UIL next
Oh
week.
gosh, that's coming up. I know. My daughter. I was a band parent once upon a time. My daughter was a flute player in the Dickinson High band. I'm very familiar with all that. The thing with, as I was telling you, was bonus was, you know, words that are you want to paint a picture. You want people to think, because all kinds of studies show that so much of our thought process is what we see, and so much of it is kind of what we think and are exposed to. So you want them thinking about things. So you don't want to talk about bruises and contusions. You want to talk about blood. You want to get them thinking about things that happened and led to this. For example, if the civil case where there's some question about, say, maybe they're not spending money to maintain their vehicle or something, you want to talk about how a decision was made that led to this, to generate that kind of thing. So, when you want to use word pictures and make Please be seated. Madam Foreperson, has the jury reached a unanimous verdict?
Yes, we have, Your Honor.
Please hand it to the bailiff. Mr. Young, if you would please stand, I will read the verdict of the jury to you. We, the jury, find the defendant, Jordan Young, not guilty.
You're going to college, man. You're going to college.
All right, thank you all very much. Pleasure to be here.
My friend, thank you so much, man.
Thank you, jury.
If we can have some thought, first of all, I want to say thank you to our special guest. Judge Kerry Neves is the presiding judge for the 10th District Court in Galveston. He's just a wonderful judge, and you can tell by the way he donates his time that he cares very much about education and building fine new lawyers and contributes to the profession. He also just does all sorts of wonderful volunteer work around Galveston County and elsewhere, I would only imagine. He is a former Marine and has been on the bench now. You're in your third?
Second term, about 6 years.
Okay, yeah, and I can tell you I practice regularly in his court, and he works so hard and has a wonderful legal mind. He's just great, and he's very courteous and kind to everybody who's in his courtroom. Anyone who is in there is just, they know they're in a special place because they are, everyone's treated with respect, everyone is heard equally, and he does not have any problem making a decision for which we are all grateful. We're very grateful. He make a good record in his court. But this is Judge Neves' 4th year to serve here, and just to finish a big day and start a next one in the morning and come here and volunteer his time that way after hearing lawyers yap all day long. It's quite a gift to us. While the jury was out, he gave feedback to the lawyers, and we're so appreciative of that. I also wanted to introduce Hank Hughes, who has been here. This is his 4th year to serve as well. Officer Hughes is Mason, and he's been a certified peace officer for
34 years.
34 years. Officer Hughes serves in many capacities in Nassau Bay Patrol. He serves as our court officer, our security officer for Nassau Bay, the City of Nassau Bay Municipal Court. And one of the things that's near and dear to my heart is Officer Hughes took it upon himself to, now I'm getting all misty, he follows the school buses in the morning, especially the elementary bus, the younger kids. And I know he checks on those older kids when it's dark and they're waiting at the school bus, and it's the high school kids early in the morning. But he follows the school bus around to make sure that everybody is behaving themselves and driving properly, and that our kids are kept safe in Nassau Bay, for which we truly, truly are grateful.
Very important.
Every day when we're out there and see him. Yeah, thank you. Our wonderful University of Houston, Clear Lake campus officers are here helping us. We're so grateful to Chief Hall and to the officers who are here. We have 3 officers. I know that all of these officers have been working long days, and the fact that they would adjust their schedules and help one another out on campus to cover them so they could be here and help us is, it's a big task, and it's a little too out of their comfort zone. So we're so appreciative, and thank you for just kind of putting yourselves out there and allow us to, maybe put you in a space where maybe you don't know the answer to a question.
They did very well.
They did. Yeah, they did. Not that happened, but you never know what's going to happen in a trial, especially a mock trial. So thank you all very, very much. We'd also like to get some photographs.
Okay.
If the jury didn't mind too, sticking around. And I'm going to turn this over to Ms. Bonus, and definitely we want to get photos of the lawyers with Judge Dukes, however you want to do that. And I know that Stephen knows exactly what to do.
still hung back.